Welcome viewers to YouTube channel Kanooni CHARCHA. Again, I am with you. New topic, new case, new Supreme Court of India judgment. Today's judgment is related to Section 141 of Negotiable Instruments Act 1881. Many amendments have been affected to this act from time to time. The title of the case, which I am here to decodify today, Susheela Padma Amma versus Messrs. Bharti Airtel Limited. I will refer in brief the facts involved in the present case. Messrs. Bharti Airtel Limited is approached by a company, Pivotal Telecom Solution Private Limited, for telecom resource, and this is and an agreement was arrived and against between both Airtel Telecom Limited and Pivotal Telecommunication. However, as appears from the facts of the case, that there remains business transactions between the relating to this telecom resource. However, the four check detailed in 3.4 of para 2 of this judgment remained unpaid. Accordingly, a complaint was filed by this Bharti Airtel Limited before the magistrate court. Against this Pivotal Telecom Solution India. Against this complaint, a petition was filed by Susheela Padmavati versus State before Hon'ble High Court of Madras, or virtually you may say quashment of the proceedings undertaken against her by the trial court. She is referred as a director of the company, but his involvement is not found in daily to-day affairs of the company. Now, this prayer of Susheela Padmavati was refused by Hon'ble High Court, and however, simultaneously a direction was made to the trial court to expedite the matter in complaint. Against this order of High Court, appellant here in this case, Susheela Padmavati approached the Supreme Court of India by way of this criminal appeal. The para 18 contains the crux of the para 18 of this judgment contains crux of the factual aspects as involved in this complaint. I will read out for the convenience of the. Please wait. Let me search out. It para 18. It will be relevant to refer here to para 16 of the complaint. This is para 18 of the judgment which I am discussing here. Para 16 of the complaint filed under Negotiable of Instrument Act, relevant sections are 138 and 142 of NIAct before the Metropolitan Magistrate Sadapat, Chennai, dated, it is a, now para 16 of the complaint, the complainant states that the accused has intention of cheating the complainant. The second and third accused herein has no intention to pay the dues and they owe to the complainant, but they owe to the complainant, instead making the complainant believe that same would be paid, and through which trying to push the liability to future. They are delaying, they are not paying the amount. It is also pertinent to note that second and third of the accused here are the directors. It is simply mentioned that the accused 2 and 3 are the directors of the companies. Promoters of the accused number 1 being the company. The accused number 2 herein is the authorized signatory who is in charge and responsible for day-to-day. There is a specific reference that accused number 2, he is authorized signatory and is responsible for day-to-day affairs of the company. This is the accused number 1. Accused number 2, the accused number 2 of the accused therein is the authorized signatory. The accused number 1 is the company, and his accused number second arrayed here is the accused number who is the authorized signatory and who deals with the day-to-day affairs of the company. Now, this is a para 18 referred referred in this judgment in order to work out whether the directors who are not concerned with the day-to-day affairs of the company are liable, can be prosecuted in terms of this section 138 of the Negotiable Instrument Act. Otherwise, a complaint can be filed against them also. They can be arrayed as accused simply because they are directors of the company. Now we will go to para 19, which is very relevant. Earlier, this Supreme Court of India, their lordships have discussed the judgment referred by the appellants in support of their in case for quash and for setting aside the order of the Hon'ble High Court. With Hon'ble High Court, I have already mentioned here that refused to entertain the prayer of quashing of the proceeding of a complaint pending before the trial court. Now, I will read out. It can thus be seen that only allegation against the present appellant is that present appellant and the accused number 2 had no intention to pay the dues they owe to the complainant. This is not more concerned. Section 141 of this Negotiable Instrument Act is a penal section. It deals with who are liable for if some offence is committed, particularly under Negotiable of Instrument Act, who are liable. No doubt company is liable. Company here has been impleted accused number 1. Next, I will add, it is stated that second accused and third accused appellant herein are the directors, promoters of the accused number 1. accused number 1 is the company, being the company. It is further averred that accused number 2, he is the accused, the authorized signatory who is in charge and responsible for it. The para 19 is a reproduction of what is mentioned in relevant para 16 of this complaint, and they have now discussed. Para 19 appears to be more relevant here. It can thus be clearly seen that there is no averment to the effect that the present appellant is in charge of and responsible for day-to-day affair of the company. It is also not the case of the respondent that the appellant is either the managing director or the joint managing director of the company. Means there is no any reference that the accused who's approaching the Hon'ble Supreme Court of India by way of this petition, this criminal appeal, is neither a joint director of the company nor a managing director. The 141 is only applicable because it is a penal section, and only the persons who are responsible for day-to-day companies are liable to be for conviction and this sentence, not all the directors. It can thus clearly be seen that averments made are not sufficient to invoke the provisions of section 141 of Negotiable Instruments Act, who are the appellant. Means the crux of the complaint, relevant para 16 of the complaint, they have discussed and draw a conclusion that this appellant, the Padma, Susheela Padma Vathy, is not directly responsible. Her case does not come within the ambit of section 141 of the Act. So now it is para 22. Now the crux of the judgment, the operative part of the judgment, you will find. In the result, we find that present appeal deserves to be allowed. It is ordered accordingly. The judgment and order passed by High Court dated 26th of April 2022 is quashed and set aside. Now High Court order or refusal to quash the proceedings of the complaint are set aside by this judgment by the Hon'ble High Supreme Court of India. The proceeding in CC, means this is a complaint reference, so and so, pending before, this is also the court's name. Now, in connection with offence, punishable under section 138, read with section 142 of NIAct, are quashed and set aside qua the present appellant. This judgment is dated 15th of August, not August, but March 2024. This is a true bench judgment. It was consisting of Justice B.R. Gave and Justice Sandeep Mehta. In para 5, I will expand and my discussion and mention here that para 5 of this judgment, you will find if there is a reference of the judgment cited by the appellant, which is those are related to section 141 of NIAct. When complaint is filed against the company, who's liable, this section 141 deals with. The judgment referred, you will find many judgments. I will read out, you will find this in para 5 of the, these are judgment. Learned counsel relied on the judgment. Learned counsel means judgment, this counsel of Susheela Padma, who was simply a director of the company in the present case. N.K. Bhai versus Shekhar Singh and others. This is one judgment. SMS Pharmaceutical Limited versus Neeta Bhalla and another. Ashok Paul Wapna versus Upper India Steel Manufacturing and Engineering Company Limited. Krishi Utpadan Mandi, this Samiti and others versus Ilvit Patna Nagar Bees Limited and another Lakshmi Dayachan versus State of Gujarat. These are judgment were referred with the contention that the being director, simple director of a company, Susheela Padmavati, petitioner, is not liable. She is not responsible for day-to-day these affairs of the company. This is para 8 I will read out for the convenience of this judgment. It could thus be seen that this court had held that simply because a person is a director of the company, it does not necessarily mean that he fulfills the twin requirement of section 34(1) of the said act so as to make him liable. It has been held that a person cannot be held liable unless at the material time he was in charge of and was also responsible to the company for the conduct of its business. Mean this is also this is the para 8 clarify all this legal aspect of the matter. The only those director, particular director, or if there is more director, managing directors who are dealing with, who are responsible for day-to-day work, they can be prosecuted, against whom the complaint can be filed in terms of one section, this section 138 of NIAct, and not there is one SMS for there is a reference in para 9 of this judgment about this SMS Pharmaceutical Limited. It is also discussed. Many judgments have been discussed in this para of the judgment, and lot corrects that section 141 relevant company. If where there is a complaint against a company, the managing director who is responsible for day-to-day affairs is liable to be prosecuted, he is liable for the penal punishment, not others. Now, in this case, last I have already read that proceedings were quashed against the appellant, Susheela Padmavati. Now, I think my viewers would have understood what is the scope of section 141 of this negotiable instrument. I think this is sufficient for today. I will again come before you with a new topic, new episode. Thank you. Thank you very much.